May I seek your lordship's indulgence in mentioning hearing list item number 18, my lord. The legal aid counsel, Mr. Jordan Romingtanga, he is unwell and has requested me to appear on his behalf, lordships, and if this matter may come up again after 2 weeks, my lord.
Okay, Miss, your name, please.
Miss Rosie
Learned counsel appearing on behalf of Mr.
Jordan Romingtanga.
Jordan. Learned legal aid counsel for the respondent number 2. You inform the other side?
Yes, I'm from
Okay,
the other
with
side
consent
also.
from the other side, press for listing the matter after
2 weeks, my lord.
2 weeks. Fair allowed.
And regarding item number 19, same prayer, my lord, but if this matter may come up as a fixed item on 1st July, my lord, if permitted.
1st of July.
Yes, my lord.
Okay. Same order. Date 1st of July.
I-
Here he is for amicus.
And in daily list, my lord, item number 11, Mr. Jordan will be appearing also. The paper book has arrived, it seems, my lord.
Item number 11.
Yes, my lord.
My lord, in item number 11, I'm for the appellant amicus, my lord. In this
You-
case, we
you
have just
received the
received the
paper
paper book. It can be listed for hearing.
You will
We have
receive
received
the paper book.
Yes, your lordship.
Okay.
It
When
can be
can
listed
it be
for hearing.
listed?
After 2 weeks, my lord.
After 2 weeks. After 2 weeks.
Oblige, my lords.
From admission column, item number 1.
Lordship, in item number 1, I am appearing for the respondent number 12, that's the contractor. During the last date, Lordship, this honorable court has passed the order. There was one issue raised that there are the potholes in the subject contract, where I made the submission that in my stretch, which has been allotted to me, there is no potholes and those are not connected to me. Thereafter, this honorable court directed the PWD to undertake a survey. Survey has been undertaken and my stretch has also been visited. In my stretch, it's trafficable. The survey report has come that I am filing. And apart from that, the authority was directed to file the NIT test report for the works undertaken. Excuse me.
What do you mean by trafficable?
Traffic is moving smoothly on that project road. Nothing adverse has come in the notice of the PWD officers who have visited the site. Excuse. One more please. No. Lordship, it's annexure P, it's annexure 2, which is the survey report. Page number 14, if the Lordship can see.
Page number 40.
14. Serial number 2 and 6, they are they work are interested to me. 2 and 4.
Serial number 2 and
2 and 4.
How can we ascertain that these photographs belong to the stress number 1 and stress number 2 and 3?
Lordship, because we have given the locations also. And earlier also we are filing by way of the same practice. We are giving the locations also. Longitude, latitude and date is mentioned, Lordship, if Lordship can.
Yes, have you gone through the photographs?
Lordship, I'm appearing on behalf of Mrs. Emily L. Changte, so I've no knowledge of it.
My friend is appearing for the authority who will be certifying this.
PWD.
NHIDCL, who is authority to me.
Please, my lords. My lords, in term of the last order dated 10/6/2026, my lord, we were directed to submit a report of the NIT. However, we have just received the report yesterday. So if your lordship will permit me to file it by way of an affidavit within a week, my lord, because we just received the report yesterday.
You offer respondent number
7 to 10, my lord.
7 to 10. So you have been granted time on earlier occasion also.
Yes, we were waiting for the report, my lord. The report we've received yesterday only, my lord.
Okay. And what is the financial progress of the work?
Project 1, there is physical progress. It's 80% and 82%. There are the two projects, project 1 and project 2. 80% and 82%.
No, I am asking you about the financial progress.
For project 1, 50%, project 2, 25%. But financial progress is nothing to do with the physical progress of the project, Lordship.
Why?
Financial project is relating to the bill, that how much amount bill has been paid to me.
Yes.
And physical progress, what the work I have executed at the site.
That has been specifically asked
Yes, Lordship.
how much you have been paid
Yes, yes,
till
Lordship.
date.
Yes, Lordship.
So can we expect that you will be able to complete the same on 7/7/2026 as assured earlier?
Lordship, by the project completion date, and if not, then there will be very minimal work, which will be by the end of the July. If not, because Lordship, after the grant of the LOA, first we have taken the work to come at a motorable condition, because there was gap in the work when PWD handed over it to the NHIDCL. NHIDCL when issued the tender, and the work was actually awarded. So first we have done those things, and thereafter from January onwards we have undertaken the physical progress. Once the traffic was motorable condition, physical progress, and January to till date we have achieved 80% and 82% of the physical progress. And because of the Lordship, because of the Iran and all these things, some aggregates issue have also come, so that has also affected our progress.
How?
Because Lordship, there was a scarcity of the aggregates in the market, and what was the aggregates prices have been double what was given, what was stipulated at the time of the tender. So in fact, the ministry has also come with the circular with this, that look, where there is no price escalation and the contract is to be done, we'll pay you for the aggregates also. And such force majeure events can also be taken into extension of the time for 2 months to 4 months. There is circular also, which earlier I had filed.
Okay. Heard, Mr.
Stephen Lalbuatse.
Learned Counsel. Appearing on behalf of Mr.
Mrs. Emily L. Changte.
Learned Counsel for the petitioner. And Mr. Your name, please?
Anil Kumar, for respondent number 12.
For the respondent number 12. Respondent number 12.
Yes, Lordship.
And Mr. Samuel
Yes, my lord.
for respondent number 7 to 10.
Yes, my lord.
7 to 10. The learned counsel for the respondent number 7 to 10 commits that yesterday he has received a report and he prays for granting him 1 week time to bring on the said report bring on record the same report by way of an additional affidavit.
Yes, ma'am.
Where allowed. The learned counsel for the respondent number 12, pursuant to the direction issued by this court, or by order dated 10/6/2026.
There was no
Yes.
direction for me to file the affidavit. However, since I am showing the physical progress of the work, therefore I have filed the affidavit.
Has filed an additional affidavit. Additional affidavit. Is this your affidavit
Yes, Lordship.
indicating the physical progress of the project? We have carefully gone through the report, and it appears that the physical progress of the project is approximately 76%. Correct?
82% for project 2 and 80% for
No,
project
you
1.
come to page number 3 of your affidavit. Approximately 76%.
That was earlier progress. That is the earlier progress as has been recorded in the order. Just 1 minute. Lordship, there is a column earlier progress as on 6/6/26, 76%, updated progress in 22. Last column, Lordship. Last.
Page 4. Page number 5.
Page number 4, Lordship.
For project 1 is project 1, the progress is physical progress is physical progress on 6/6/2026 is 76%, and updated project on 22nd of June 2026 is 80%. And in respect of project number 2, earlier progress on 6/6/2026 was 73%, and updated progress on 22nd of June 2026 is 82%. The learned counsel for the respondent number 12 also submits that though the entire work may not be completed by 7/7/2026 as assured earlier, the same would be completed by the end of July. End of July 2026. Accordingly, further, the learned counsel for the respondent number 12 submits that a joint inspection was carried out and there is no petrol in respect of the
Subject
number-
contract awarded to the respondent number 12.
respondent number
12.
12. Respondent number 12. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that a recessal lays the matter when
1st of July, madam. Next week, Wednesday.
no, you see earlier date was date of completion was fixed on 7/7/2026. Let it be on 7/7. It will be a holiday. So let it be immediately after reopening of the vacation. In the meantime, he will file additional affidavit indicating the present status, the status on that day
Yes, Lordship.
regarding physical as well as financial progress.
Lordship, may I one thing? Financial progress is subject to the availability of the releasing of the funds by the NHIDCL. So
Yes.
I will be able to file if my friend take this issue financial with regard to the financial progress.
Yes, you can indicate in your affidavit.
Yes, my lord.
On next date, the learned counsel for the respondent number 12 shall file additional affidavit bringing on record the current status of the aforementioned projects. The learned counsel for the respondent number 7 and 10 shall also indicate in his affidavit regarding the financial progress of the project. List accordingly on 13th of July.
15, my lord, will be a DVD Wednesday, my lord.
Wednesday.
15.
Wednesday. 15.
Yes, my lord.
Okay.
Deeply obliged.
Item number 2.
May I please, Your Lordship?
Yes.
Yes, my lord. This is a criminal appeal, my lord. File for modification, for reduction and modification of the bail bond amount, my lord. My lord,
Yes, Mr. Zoram Sana, where is your objection?
Lordship, I have filed it yesterday.
Yesterday.
Madam. Oh, it's there.
So what is the maximum punishment prescribed under the section under which the case was registered?
my lord, uh, on section 61 clause 2, it did not, it's a criminal conspiracy, my lord. That did not mention the punishment, but in UAPA 23 clause 2, my lord, 10 years. Up to 10 years, my lord. And in the Arms Act, not less than 10 years, my lord.
So maximum is 10 years.
Yes, my lord.
So 23(2) unlawful activities and 25(1) Arms Act 1A.
So at the time of granting bail,
Yes, my lord.
The bail amount was 25 lakhs.
25 lakhs, my lord.
Subsequently,
And
it has been reduced to 10 lakhs.
10 lakhs, my lord. And that is on 1st of December 2025, my lord. And till now, we cannot afford that, my lord. We cannot comply with that condition.
10 lakhs.
Yes, 10 lakhs and the regular government servant.
Government servant also you don't have.
Yes, my lord. Since we are just a layman and none of our family member are working under the government, my lord. I have, my lord, if I may allow to submit some citation, my lord. I have.
Yes, you can.
My lord, in criminal appeal number 120 of 2025, Gudan Rup Narayan versus State of Rajasthan, the Honorable Supreme Court has held that, my lord. I have highlighted the relevant portion, that is page number 3, my lord. Point number 13 to 16 is my prayer, my lord. In which the apex court has also that even the 1 lakh bail bond is too excessive, my lord. Which is also same to the punishment of the present case, my lord. And my lord, if may I read, my lord?
Not necessary.
My lord.
This Motilem Das is a old decision on this point, written by Justice
Yes, my lord.
Kisnoyer. Anyway, Mr. Zoramson, what is your objection?
Your Lordship, yes. The church sections, my Lord. I'd like to rectify my learned friend regarding 25 Arms Act, section 25 1AA, Your Lordship.
Yes.
The punishment is life, and not less than 10 years. And for 23(2) of UAP Act, it's 10 years. So
Now,
now,
you
my
see,
Lord,
considering the merit of the case, the learned trial court has granted the bail.
my Lord, granted the bail, and thereafter, my Lord, as it is there in the record, it's shown in the record that it was thereafter subsequently on their application reduced to the present condition, my Lord. Earlier it was 25 lakhs that they a bond. It's not that they have to deposit. No, it's only a bond.
Is it possible for a daily wage earner to furnish such kind of surety?
The only thing, my Lord, that we have to bear in mind is that to make sure that they regularly attend the court, my Lord. That's all, my Lord.
Pardon?
That they have to regularly attend, just to make sure. Because now, my Lord, regarding my objection, my Lord, if I may take before that, my Lord, a lordship to their address that they themselves enclose in the application which they filed before a lordship to them, my Lord. The
No,
document.
are they not local resident of Mizoram?
They said that they are local, that is as per their submission, my Lord. The arresting officer also stated as their statement, my Lord, that we assume that will be correct. But now, when we have inquired it, they here also, my Lord, submitted that they are now presently residing in Aizawl, not in the residence which they earlier stated, my Lord. They earlier
Maybe.
stated that they are respectively the applicant number 1. The petition number 1 earlier was resident of Thainzawl, which is a town not far from here also. And they later stated that they are resident of Klangdong. But herein, my Lord, in the copy of Aadhaar card, my Lord, that they enclose here in the present petition, my lord. It seems that he is a resident of Din Tarveng Aizol, my lord. So, which is to be believed, man. So actually, it's very, very hard to believe which is their correct address also.
No,
So
maybe, but
in such circumstances, my lord,
to
once
ascertain
they are
his
released,
correct address is not the business of this court.
but my lord, my ground is that once if they release, where are they to be found? Once they abscond, my lord, where are they to be found by the trial court, my lord? That if they abscond, my lord, because the charges herein are not simple charges, my lord. It's a recovery of 6 numbers of AK-47 rifles
Maybe.
and 10,000 numbers of ammunitions, live ammunitions and magazines and all these items, my lord, which they have concealed it somewhere in the forest, and they themselves recover it on being led by them, my lord. So actually, once they are released, it's all right, my lord. We have not also challenged the bail order, my lord. But it's the only condition that we have to make sure that, how to make sure that they actually and regularly attend the court.
What were the other conditions?
The other petitioners, my other accused in the present petition, one already released on bail, my lord. Also
No,
executed.
what were the other conditions imposed while granting the bail?
If I may take a lordship to
42.
Page 42.
page 16, my lord, of the present petition. This is the initial bail order. If I may take a lordship to the operative part, which is at page 36.
And what is the date of this order?
This was
The bail,
issued
the bail application is on 9 September, my lord. 9 September 2025.
9 September 2000.
25. And the criminal miscellaneous application is granted to us on 1st December 2025.
The other conditions, Your lordship, are page 36. The
So
bail conditions.
there is existence of one condition that they will not leave without the permission of the court.
My lord.
That is there.
That is there. They shall attend court regularly. They shall not directly, indirectly make inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or tamper with evidence. They shall not leave Mizoram
to appear for all the departments. That is why it has to be a consolidated affidavit. And as for the
There is no conflict between these two departments, right?
uh,
Or there are some issues.
there are some issues with
So
regards
if there
to
are some issues, whether it can be filed, whether you can file a consolidated affidavit for the two departments.
yes, Your Lordship, the conflict has to be resolved at the secretary level. The chief secretary, they've had a meeting with the chief secretary, and as to the compliance of the forest laws, directions have been given to the public works department to comply, and they've complied as such. Now, the only modification that is required in the affidavit is regards to the record regarding the deemed forest that has to be submitted.
So you can file an additional affidavit, or you can file an affidavit on behalf of PWD. What's the need of like withdrawing this and filing a place?
Your Lordship, that is my instruction. That is what has been desired by the
No, instructions
department.
will always come, but like you, as a lawyer, you have to apply your mind.
Yes, Your Lordship. If I may be given, but Your Lordship, if they are not agreeing to the initial submissions, so that also becomes a conflict in itself, Your Lordship. So if I may be allowed to just withdraw this, and also in the interest of both the departments, Your Lordship, because otherwise later on there might be a conflict.
Okay, then Chief Secretary will be asked to file the affidavit, consolidated affidavit on behalf of both the department.
Okay, yes, Your Lordship.
So both the departments have different heads. Correct. So now
yes.
thing is that if you want to file a consolidated affidavit, that has to come from the chief secretary as a government representative,
Yes, Your Lordship.
as my senior has already spoken.
The learned counsel for the respondent number 129 submits that she may be allowed to withdraw the earlier affidavit and to file a consolidated one concerning both the department.
Yes,
both
Your
the
Lordship.
department. Pair allowed. The chief secretary, Dr. Mizoram is accordingly directed to file a consolidated affidavit on behalf of both the department. List the matter after 1 week,
Yes, Your Lordship, if the matter may be listed again on the 15th of July.
15th of July. Yes, any objection?
No objection, my lord.
15th of July.
Much obliged, Your Lordship. Obliged, my lord.
Item number 6.
Hello, this is jail appeal under POCSO, and notice has been sent.
Your Lordship, notice on respondent number 2 was duly served on 25/5/2026. But today none appeared for the respondent number 2. And amicus is not yet appointed.
Not yet
Yes.
appointed.
Yes, Your Lordship.
Heard Ms. Kiangte, learned additional PP for the state respondent. The learned additional PP has produced one service report upon the in respect of service of notice upon the respondent number 2. Then it appears that notice has duly been served upon the respondent number 2, but the respondent number 2 remain unrepresented today. In that view of the matter, who can be appointed?
Your Lordship, Seatlan Thiang Lima. I think he
Pardon?
will be Seatlan Thiang Lima.
The number 3 in the list.
Yes, Your Lordship. I don't know the serial number, but Seatlan Thiang Lima.
Si Thang Lima.
Yes.
Okay. He is appointed as legal aid counsel to represent the respondent number 2. The learned additional PP has also pointed it out that since this appeal is preferred from jail, there is a requirement of appointing amicus to represent the appellant. Accordingly, it is provided that who can be appointed as amicus?
Your
Where is the
Lordship,
list?
Is there any list of amicus curiae?
No, Your Lordship. Your Lordship, H. Lanma Somi may be appointed.
Pardon?
H. Lanma Somi.
Ace.
Yes, H. Lanma Somi.
Ace
There's no
Lanasamy.
specific list.
Accordingly, Mr. Ace Lanasamy is appointed as amicus to represent the appellant. List the matter after vacation.
Yes, Your Lordship, meanwhile, paper book may be prepared by the registry because TCR has already received.
Since the TCR has already been received, Regis shall prepare the paper book and list the matter immediately after reopening of the vacation. Regis shall reflect the name of legal aid counsel and also the amicus in the cause list.
Deeply obliged.
Item number 8.
May I please your lordship?
Yes.
My lord, item number 8 and 9 can be taken up together because it is the writ appeals are filed against the same common judgment.
Yes.
Common judgment dated 6/2/2025. My lord, in the IA 116,
Yes.
my lord, would come, if my lord would come to para 3, my lord. The delay is 135 days in both the writ appeals. IA 116 and IA 117 for condonation of delay, that is item 8 and 9, both, my lord. Same day it has been filed and delay is 135 days, my lord.
But in which paragraph of your application you have explained the delay?
Yes, my lord, there are many paragraphs. I am just citing those paragraphs, my lord. In para 4, my lord, in gist I am telling, my lord, in para 4 I have stated that I do not have a office at Aizawl and my head office at Delhi, and the record was voluminous, so it has to be sent to Delhi. So there was some delay, my lord, in para 4, my lord. Then, my lord, may I please, my lord?
So when the head office received the record,
My lord, every day is not pointed out, my lord, because the office does not have that details, my lord. But I am coming to that, my lord. There are some other issues also, my lord. I am just taking it out, my lord. My lord, MHA is the paying authority, my lord, Ministry of Home Affairs, and their view is essential. That is written in para 5, my lord. And they have given their instructions, because they are the ultimate paying authority, they have given their instructions to file writ appeal on 8/5/2025, para 9, my lord. By letter, Annexer 1 letter. Sorry, my lord, Annexer 4 letter. And thereafter, my lord, the financial involvement was not quantified by the Deputy Commissioner, because the matter relates to, my lord, the award has already been paid. Whatever the award, it was paid. Only, my lord, the claim was relating to interest and solatium, which the petitioner has come up after, in one of the writ petition, it has come up after 8 years, and in another it has come up after 11 years, my lord. In item number 8, that is writ petition 75 of 2019, petitioners have come up 8 years, and in the other one, item number 9, they have come up after 11 years, my lord. So, we have requested for some documents, how the Deputy Commissioner has calculated the solatium, the assessment seat and all, and till date we have not received that, which is also a part of the writ appeal. My lord, the writ petition itself is after 8 years and 11 years, and I have only, my delay is only 135 days.
yes, any objection from the other side?
My lord, I am also relying on 2 citations, my lord, that I can.
Yes.
My lord, one is, if local council Lute has handed over that citation, my lord. This is, my lord, very old citation. It is very much applicable till date, my lord. Collector Land Acquisition Anantnag and another versus Katiji and others. My lord, para 3. May I read that paragraph 3, my lord?
Yes.
My lord, the legislature has conferred, my lord has got that para 3?
Got it.
My lord, the legislature has conferred the powers to condone delay by enacting Section 5 of the Indian Limitation Act of 1963 in order to enable the courts to do substantial justice to party by disposing of matters on merits. The expression sufficient cause employed by legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the ends of justice, that being the life purpose for existence of institution of courts. It is common knowledge that this court has been making a justifiably liberal approach in matter instituted in this court. but the message does not appear to have percolated down to all the other courts in the hierarchy. And such a liberal approach is adopted on principle as it is realized that, number one, ordinarily a litigant does not stand to benefit by lodging an appeal late. Number two, refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merits after hearing the parties. Number three, every day delay must be explained does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. Number four, when substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested rights in injustice being done because of a non-deliberate delay. Number five, there is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. Number six, it must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. My lord, in the other citation, my lord, in para 34, Shivraj Singh versus Union of India, this citation, collector land equation, has been upheld, my lord. May I read 34, my lord?
Yes.
The order under challenge in this appeal is dated 21/12/2011. It was rendered at a point when the decision in Katiji, which I referred to, my lord, Ramegoda, Chandramani, KV, Aishumma, and Lipok were holding the field. It is still holding the field. This is a very new citation, my lord. It is not that the said decision do not hold the field now, having been overruled by any subsequent decision. Although there have been some decision in the recent past, State of MP versus Verulal, in one such decision apart from University of Delhi, which have not accepted government lethargy, tardiness and indolence in presenting appeals within time as sufficient cause for condonation of delay, yet the exercise of discretion by the High Court has to be tested on the anvil of the liberal and justice-oriented approach expounded in the aforesaid decision, which have been referred to above. So, my lord, my delay is only 135 days, my lord. Very negligible delay, my lord.
Negligible?
135 days negligible.
My lord, in terms of what has been given
And
by...
more so because there is no explanation of anything. You have just simply made a vague statement that
No,
we,
no,
have,
my
we,
lord,
have, we have received the documents.
No,
and,
no,
and
my
how
lord,
much time
in other-
see, Mr. Counsel, let me tell you one thing. First thing is that, first point that you have taken, that the case was going on in Aizawl. Aizawl, you do not have an office in Aizawl. That's why the copy of the writ petition was not available in Delhi. Then how they were instructing you from Delhi? Without
is
having
not
the
my-
copy of the writ petition?
My lord, entire voluminous document I have sent it from Aizawl to Delhi.
Correct, that should have been sent much before, because you are getting instructions from them from Delhi. So they must be aware of the writ petition. They should have been aware of the writ petition.
No, my lord, I was getting instructions from Gauhati office. But the ultimate authority is the Delhi office. That has been said. Anyway, my lord, there are other grounds also. That might not be very accommodative ground, but my lord, there are other grounds also, my lord. I have sent a letter to DC for some documents regarding assessment sheets of calculation of solatium to calculate the financial involvement. That has not been received till date, my lord.
But your petition was filed for what? That petition that was filed by the petitioner for what?
My lord,
The petition was filed for what?
Which one, my lord?
The initial petition that, which has been, against which you are filing the appeal, it was filed for what?
My lord, I was the respondent.
Correct,
there.
I'm saying, that's what I'm saying, why it was filed?
It was for solatium and interest.
So you
but
were aware about the fact that like solatium and all these things will come into play? And you have been waiting till the disposal of the case to seek,
No, my lord,
seek
they
for
don't
the
think-
seek for the documents of solatium or whatever assessment from the DC's office till the disposal of your writ petition?
No, financial involvement has to be seen, my lord, because they have included some of the items which were not even instructed by the High Court. Honorable Single Judge. Those were part of the writ appeal, my lord.
Okay, any objection by the
Yes,
other side?
Lordship, we have some serious objections. Lordship, the impugned judgment was dated 6/2/2025. 6/2/2025. And before the judgment was passed, the appellants had sufficient opportunity of getting whatever documents that's required for the purpose of pursuing the case or examining the merit of the case. And Your Lordship, as stated by the learned counsel for the appellant, they have relied upon, they have said that the non-availability of certain documents had also caused some delay in preferring the connected appeal. In this connection, if I take Lordship to the judgment of the Apex Court in 2025 SCC online, SC 1969. 1969, yes, para
repeat the
197.
citation.
Yes, that is Shivama versus Karnataka Housing Board and others. If I take Lordship to,
This is the Justice Pardiwala's judgment?
yes, Your Lordship. It's at page 196, Your Lordship. Para 196. May I take Lordship to the relevant para, that is page 73? No. Yes, page 73.
You have furnished the copy?
Copy ka diya ka? (2025)
Para?
Para 196.
196.
May I read, Your Lordships?
Yes.
In State of Madhya Pradesh versus Berulal, decided in 2020 10 SCC 654, this court expressed its deep anguish over the routine manner in which the state and its instrumentalities continue to seek condonation of delay on the pretext of bureaucratic inefficiencies. It held that the earlier decisions that had afforded a degree of leeway for such inefficiencies no longer reflects the correct position of law insofar as condonation of delay is concerned. This court held that in view of the decision of Postmaster General Supra, any delay as a result of unavailability of the documents or the process of arranging for them through bureaucratic process works is no longer an acceptable reason or excuse to condone such delay. The relevant observations read as under, quote, we are constrained to pen down a detailed order as it appears that all our counseling to the government and government authorities has fallen on deaf ears. The Supreme Court of India cannot be a place for the governments to work in when they choose, ignoring the period of limitation prescribed. We have raised the issue that if the government machinery is so inefficient and incapable of filing appeals or petitions in time, the solution may lie in requesting the legislature to expand the time period for filing limitation for government authorities because of their gross incompetence. That is not so. Till the statute subsists, the appeals or petitions have to be filed as per the statutes prescribed. Para 3, the quoted para 3. No doubt, some leeway is given for the government inefficiencies, but the sad part is that authorities keep on relying on judicial pronouncements for a period of time when technology had not advanced and a greater leeway was given to the government. This position is more than elucidated by the judgment of this court in Postmaster General versus Living Media. And para 97, this court in Berulal Supra further cautioned that where any public authority persists in approaching the courts for condonation of delay on such feeble and untenable grounds would not only be denied the indulgence of condonation, but also be imposed with cost for wastage of judicial time. The relevant observations read as under. We are thus constrained to send a signal, and we propose to do in all matters today, where there are such inordinate delays that the government or state authorities coming before us must pay for wastage of judicial time, which has its own value. Such costs can be recovered from the officers responsible. Your Lordship, what the learned counsel for the appellant has stated is that as per para 8 of his application, he had sought for certain documents from the Deputy Commissioner Lunglei to furnish him such letters as stated in the said paragraph, subclause 1, 2, 3, and 4, and that till date the same has not been received. That appears to be one of the grounds of his explanation for the condonation of delay. But till date, he has not received, he said. But the appeal has been filed some time back, and in the process there has been a delay of 135 days. Now, what has been laid down by the Apex Court is that such action or such attitude on the part of the government is not permissible, as clearly highlighted here in 196, paragraph 196 of the judgment. And, Your Lordship, a perusal of the application right from the start, it had stated certain facts about the case of the respondents and what has been sought for in the writ petition. And now there has been a delay of 135 days under para 3, and under para 5 it says that they have filed the appeal at the instance of the Ministry of Home Affairs, not of their own. What they have stated is that in para 5, the applicant states that although the applicant herein, writ appellant, has disbursed the amount in respect of so and so, however, the said amount being received by the applicant herein, writ appellant from Ministry of Home Affairs, and as such, the view of Ministry of Home Affairs is very much essential for the present case in hand. Inasmuch as in the event the applicant herein or writ appellant is to be provided additional amount in terms of the judgment and order dated 6/2/2025, passed in so and so, the same is to be first released from Ministry of Home Affairs, and only then additional amount can be paid by the applicant herein or the writ appellant. Lordship, there is no indication that the MHA is aggrieved. There is no grievance on the part of the MHA. When just because the additional amount is to be derived from the MHA, and at the instance of, according to them, and the instance of the MHA, the present appeal has been filed after so much of delay. And what has been stated here, in the reference letter, which is at which is at page 84 of the application, which is annexure 4. It's a letter dated 2025. 8/5/2025. May I read the content of the letter, Your Lordship? Para 2. In this context, a copy of legal opinion of Mrs. Zarem Sangpui, CGC, Mizoram, received through BSF is also enclosed herewith for information and taking further necessary action in this matter. EPIL should also ensure not to make Union of India as respondents in these matters. So, Union of India does not like to be even shown as a respondent, but it has been shown as pro forma respondent. Anyway, further, EPIL is also requested to get inputs from BSF in this matter and update this ministry accordingly. And subsequent page is the opinion of the CGC. Reading of, though not very clear, reading of the opinion. Last paragraph, may I take a lordships to last paragraph of the opinion at page 86. Whereas, may I read lordships?
Yes.
Whereas the said WPC number 156 of 2017 was not handled by me, it was handled by Mr. A.H. Barbuya for Union of India on behalf of respondent number 4 MHA, Union of India, and respondent number 5 EPIL. As such, it is difficult to ascertain by me whether it was similar to the present writ petitions regarding market value of the land, indicating in the draft award based on which the petitioners claim compensation. As such, it is hereby advised that you may go through carefully the draft award based by the petitioners in WPC number 156 of 2017, Jagadish and 320 others versus State of Mizoram. Therefore, kindly go through the WPC number 156 of 2017 to ascertain as to whether the said case is similar to the present case or not. If it was similar, the present case decision of the Apex Court in SLPC number 4 so-and-so, white order dated 4/1/2024, has been binding to all the subordinate courts. In this connection, Your Lordship, the legal advice tendered by the CGC is not that they should file an appeal, but that if there is a reasonable ground for filing an appeal, then they may go for an appeal. But if the case is covered by the said case, that is WPC number 156 of 2017, for which the SLP was filed and which was dismissed, then they have to take their own decision. There was no indication in this advice that they should file an appeal. So, taking this letter as a ground for filing an appeal, the MHA had instructed the authority concerned to take necessary decision for whether to file an appeal or not. So, Your Lordship, there was laxity on the part of the appellants. Even there was, I should say, bureaucratic inefficiency is there, and they are not sincere about what was the result of the writ petition, because Your Lordship, they did not pursue the matter diligently. In this connection, if I may rely upon the judgment of the Honorable Apex Court in Ajit Singh, Thakur Singh, and another versus State of Gujarat, 1981, 1 SCC, page 495. Page 495, para 6, Your Lordship. Para 6 at page 497. If I take Lordship to half of the said para 6, with a sentence starting from, the truth appears to be.
Yes.
Got it.
Yes.
The truth appears to be that the appeal was not filed at first because the state government saw no case on the merits for an appeal, and it was filed only because the High Court had observed, and that was long after limitation had expired, that the case was fit for appeal by the state government. Now it is true that a party is entitled to wait until the last day of limitation for filing an appeal. But when it allows limitation to expire and pleads sufficient cause for not filing the appeal earlier, the sufficient cause must establish that because of some event or circumstances arising before limitation expired, it was not possible to file the appeal within time. So this is the period prior to the expiration of the limitation period needs to be explained. No event or circumstances arising after expiry of limitation can constitute such sufficient cause. There may be events or circumstances subsequent to the expiry of limitation which may further delay the filing of the appeal, but that the limitation has been allowed to expire without the appeal being filed must be traced to a cause arising within the period of limitation. In the present case, there was no such cause, and the High Court erred in condoning the delay. Even in an instant case, Your Lordship, what has been explained as regards the period of 30 days, that is the period of limitation, before the expiry of that limitation, nothing has been said. Now, they woke up only after the award, was implemented by the Deputy Commissioner making so-and-so assessment. And when the assessment was sent, they woke up and said, it may be better to file an appeal. So for that,
So basically, that limitation period which
Yes,
is
sir.
prescribed, so that has to be also explained.
yes, Your
So
Lordship.
that has been
When there's a
that
delay,
has been said in
yes.
the other assessment also that you have referred to.
Yes.
The
My lord,
Simbabmas case.
I have only one objection, my lord. Learned
And-
senior stated that there was no instruction from MHA to file an appeal. My lord would come to 84, which my learned senior skipped it in the first paragraph
Mr.
itself.
Goswami,
My
let
lord.
the learned senior counsel complete his argument.
Yes, my lord.
Yes, let me read it for him, Your Lordship.
First paragraph.
First paragraph is, reference is invited to EPIL's letter number so-and-so, dated 29/4/2025, on the above mentioned subject, and to say that EPIL is requested to file an appeal against the order dated so-and-so in the matter of WPC number so-and-so at the earliest to defend the interests of Union of India in these cases. This is, okay, this is a request on the part of the MHA. And if, my humble submission is that if the MHA is at all aggrieved, why should it not file the appeal by itself? Why should it try to put its hands in the hole of a snake? Lordship, this attitude of the MHA is also not very healthy. If they say that they are not happy with the situation, they have every right to come up and file an appeal, but they did not come up. And they simply made a request, and that on the basis of the legal advice tendered by the learned CGC, which we have read out. And in this connection, Your Lordship, as a perusal of the application can well demonstrate that there is no explanation of the delay, only making a chart as to what had happened. And these are within the, it is not that all these things are not within the control of the appellants. It's all within the control of the appellants. They could have done this much earlier. Immediately after passing of the judgment, they could have acted, do anything that is required for preferring an appeal. But waiting for the period till it expired, till the limitation period expired, and when the the Deputy Commissioner had made the assessment. They simply said we should file an appeal. That is not very healthy, Your Lordship. If I continue to read certain paragraphs of this judgment of Sivama, which is very interesting, and it is, in fact, it deals with most of the cases which were decided prior to the Postmaster General, then as per the ratio laid down by the decision in Postmaster General, which we have 2012 3 SCC 563, Postmaster General's case, Postmaster General versus Living Media, 2012 3 SCC. Since this judgment has made a reference to this Postmaster General's case exhaustively, I'll not directly deal with this Postmaster's case. Your Lordship, a perusal of this judgment at para 172. At para 172 of the judgment, it says, the view on the subject of condonation of delay prior to decision of Master General, Postmaster General, para 172, prior to the landmark decision of this court in Postmaster General versus Living Media India Limited, 2012 3 SCC, the practice that was in place consistently leaned in favor of affording a degree of latitude to the state and its instrumentalities in matters of condonation of delay. The rationale underlying such an approach was the recognition of the peculiarities of governmental functioning, which, unlike private litigants, is impersonal, heavily layered, and subject to multiple levels of procedural clearances before culminating into a decision. So, all those judgments prior to Postmaster General case has been analyzed, threadbare, Your Lordship, such as the Special Tehsildar Land Acquisition versus KV Aisuman and Haryana Chandramani, State of Haryana versus Chandramani, the State of Nagaland versus Lipok Au, and G. Ramegowda versus Special Land Acquisition Officer, Indian Oil Corporation, cases, and finally, if I take a Lordship to page para 192, this is the second portion of the judgment. Shift in jurisprudence on condonation of delay after decision of Postmaster General. There is a shift prior to the Postmaster General's decision. It was leaning in favor of the government because of number of layers in the governmental functioning. But here, after this judgment, it says at page para 192, however, despite the aforementioned exhortations of this court in Chandramani Supra and Lipokau Supra, the same largely remained unheeded as the state and its instrumentalities continued to approach the courts after significant delays under Section 5 of the Limitation Act, though it were a license for the indolence and institutional lethargy. It was, Parat 193, it was in this backdrop, particularly the persistent disregard of the laws of limitation by the state and its instrumentalities that compelled this court in Postmaster General Supra to deviate from early practice of extending unwarranted leniency governmental agencies and to emphasize that the law of limitation binds the state no less than the ordinary litigant. The said decision is in three parts. First part, this court held that claims of government and its functionaries being an impersonal machinery and inherited with bureaucratic methodology can no longer be accepted to excuse delays under Section 5 of the Limitation Act in view of the modern technologies being used and available. The relevant observations read as under, quote, 27. It is not in dispute that the persons concerned were well aware of or conversant with the issues involved, including the prescribed period of limitation for taking up the matter by way of filing special leave petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent persons familiar with court proceedings. In the absence of a plausible and acceptable explanation, we are posing a question why the delay is to be condoned mechanically, merely because the government or a wing of the government is a party before us. 28. Though we are conscious of the fact that in a matter of condonation delay, when there was no gross negligence or deliberate inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. Secondly, this court in Postmaster General Supra held that it was high time that practice of condoning delay merely because the litigant is a government entity was done away with, and that delay should be condoned only where there is a reasonable and acceptable explanation for such delay, and was accompanied by a bona fide effort. It further observed that the usual explanation of bureaucratic inefficiency and of procedural red tapeism can no longer be accepted. The relevant observation read as, para 29 has been quoted. In our view, it is the right time to inform all government bodies, their agencies and instrumentalities, that unless they have reasonable and acceptable explanation for the delay, and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years, due to considerable degree of procedural red tape in the process. Like what has been stated here is that we do not have proper office in Aizawl, and we have a main office in Delhi and Gauhati. All those things may not be a proper excuse. And third, lastly, as regards the earlier line of thought that if meritorious causes of advance by the state or any of its instrumentalities are dismissed on the ground of delay, the resultant hardship would ultimately fall upon the public exchequer and thereby the public at large, was emphatically rejected by this court. It held that condonation of delay is a matter of exception and cannot be treated as an anticipated privilege accruing to governmental bodies by reason of their hierarchical structure or bureaucratic methodology. The law shelters everyone under the same light and should not be swilled for the benefit of a few. Thus, the plea of public interest cannot by any stretch be used as a carte blanche for official inaction. It observed that government departments, far from being entitled to presumptive indulgence, are in fact under a higher obligation to discharge their functions with diligence, vigilance, and scrupulous regard to limitation. The relevant observation read and as under. Para 29 has been quoted. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. The law shelters everyone in the same light and should not be swilled for the benefit of a few. Your Lordship, I have taken through Your Lordships to para 196, and 197. All the third portion is the ratio of the decision of Postmaster General starting from para 204.
Is there anywhere in this judgment like that that Kadzis has been discussed improperly?
Kaji is of prior to the
So why this court is keen on knowing this is that talks about the substantial justice.
yes, Your Lordship, para 196. 196. There is a reference to Kaji.
Yes.
Yes. Para 3 has been quoted.
Yeah, that
Yes.
you have already read out.
Yes. And all the judgments after the decision in the Postmaster General has also been analyzed.
Yes, they have
Under
been
the ratio of decision of Postmaster
correct.
General.
That those have been elaborately
And
discussed.
Lordship, though it has been a little bit lengthy, if I take Lordship again to pay para 212. Lordship.
Yes.
The law as it presently stands, the decision of Postmaster General Supra is unambiguous and clear. Condonation of delay is to remain an exception, not the rule. Governmental litigants, no less than private parties, must demonstrate bona fide, sufficient and cogent cause for delay. Absent such justification, delay cannot be condoned merely on the ground of the identity of the applicant. And para 214, what has been conveyed in so many words by the decision of Postmaster General is that while excuses premised solely on bureaucratic lethargy cannot by themselves constitute sufficient cause, there may nonetheless be circumstances where the explanation offered, though involving bureaucratic procedures, reflect a genuine and bona fide cause for the delay. In such instances, the true test is whether the explanation demonstrates that the state acted with reasonable diligence and whether delay occurred despite efforts to act within time. Where such bona fides are established, the court retains the discretion to condone the delay. And para 234, Your Lordship. Para 234.
Yes.
Even otherwise, it is no more res integra that law of limitation has to be applied all, but the same and with all its rigor, even if it may harshly affect a particular party. In Basawaraj, this court observed that the result flowing from a statutory provision is never an evil. A court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. Even if the statutory provision may cause hardship or inconvenience to a particular party, the court has no choice but to give full effect to say it is based on the legal maxim, the law is hard, but it is the law. The relevant observations read as under. Let me read the underlined ones, Your Lordship. It is a settled legal proposition that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribes. The court has no power to extend a period of limitation on equitable grounds. A result flowing from a statutory provision is never an evil. A court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. The legal maxim, the law is hard, but it is the law, stands attracted in such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. Finally, may I take Lordships to the concluding paras at page para 261, page 98. Conclusion. Thus, for the reasons aforesaid, the impugned order of the High Court deserves to be set aside. Before we proceed to close this judgment, we deem it appropriate to make it abundantly clear that administrative lethargy and laxity can never stand as a sufficient ground for condonation of delay, and we want to convey an emphatic message to all the High Courts that delays shall not be condoned on frivolous and superficial grounds until a proper case of sufficient cause is made out, wherein the state machinery is able to establish that it acted with bona fides and remained vigilant all throughout. Procedure is a handmaid of justice, as is famously said, but courts, and more particularly the constitutional courts, ought not to obviate the procedure for a litigating state agency, who also equally suffer the bars of limitation from pursuing litigations due to its own lackadaisical attitude. 262. The High Courts ought not to give a legitimizing effect to such callous attitude of state authorities or its instrumentalities, and should remain extra cautious. If the party seeking condonation of delay is state authority, they should not become surrogates for state laxity and lethargy. The constitutional courts ought to be cognizant of the apathy and pangs of a private litigant. Litigants cannot be placed on situations of perpetual litigations, wherein the fruits of their decrees or favorable orders are frustrated at later stages. We are at pains to reiterate this everlasting trend and put all the High Courts to notice not to reopen matters with inordinate delay until sufficient cause exists, as by doing so the courts only add insult to the injury, more particularly in appeals under Section 100 of CPC, wherein its jurisdiction is already limited to questions of law. 263. Limitation periods are prescribed to maintain a sweeping scope for the lease to attain for finality. More than the importance of judicial time, what worries us is the plight of litigant with limited means, who is to contest against an enormous state and its elaborate and never-exhausting paraphernalia. Such litigations deserve to be disposed of at the very threshold, because, say, if a party litigating against the state for whatever reason is unable to contest the condonation of delay in appeal, unlike the present case, it reopens the lease for another round of litigation and leaves such litigant listless yet again. As courts of conscience, it is our obligation that we assure that a litigant is not sent from pillar to post to seek justice. Very beautiful observation, direction, and Lordship judgment made by the Apex Court. Lordship, the respondents are the landowners whose lands have been taken away by the action of the state. And it is for the purpose of construction of Indo-Myanmar, Indo-Bangla border fencing and roads. And in the process, the award was prepared and it was approved by the state authorities and it was acted upon. And in fact, the principal award without the interest and solicium had already been paid and deposited by the authorities, that is MHA and the present appellants. They have deposited and it was disbursed. What has been sought for is for additional payment as per law. The statutory rights of the landowners as provided under Land Acquisition Act 1894. That has been violated, and against that the petitioner had approached this honorable court by way of the connected writ petitions. And that had been decided in favor of the writ petitioners, saying that they're entitled to all this because the law says so. And when it is at that time, at that stage, nothing was, no protest or no objection was made, only when it was calculated and sent for payment. That objection has been made. And that was after 135 days of delay, the present application, the present appeal has been filed, trying to explain away all those periods. But what has been stated by the Apex Court in the earlier case, that is Ajit Singh Thakur Singh, 1981, Lordship, they have not made proper explanation of even the period prior to limitation. They have to explain all that. Without making proper explanation, this Honorable Court may not allow the condonation application. Lordship, in view of all this, it will be in the interest of all concerned that the application is rejected, the appeal dismissed, and the appellant, the writ petitioners paid their due share of the compensation as per law and as decided by the learned single judge in connection with the writ petitions. There are two writ petitions which are decided by a common judgment, Your Lordship. So, with that, I conclude.
My Lord, if I may, I'm for respondent number 463 in item number 8, and in item number 9, I'm for respondent number 556, Union of India. I have no objection with regards to application filed by the present applicant, my Lord.
Okay. Yes, Mr. Goswami.
My Lord, only one line, because learned senior has said that the original award has been paid. Yes, my Lord, it has been paid. Why interest and solatium we are objecting that it should not be paid? Because, my Lord, 11(1) of Land Acquisition Act 1894 states that the true area of land to be mentioned in the award. In the earlier award, there was no mention of any area, not a single whisper how much land has been acquired. It stated that amount claim has been paid, amount paid. So it comes under 11(2). That is an arrangement. If there is an arrangement, question of solatium and interest is not required to be paid. That is the reason we have brought in the writ appeal. 11(1) states that area to be mentioned, and 11(2), if in case of any arrangement, and this is showing that amount claim has been amount paid. Assessment sheets are showing. I am not going back to the writ appeal or writ petitions, but just I am clarifying. And 11(2) states that if in case arrangement has been made between the petitioner, we have paid as persons interested. And when persons interested are paid as a way of arrangement, then solatium and interest is not required to be paid, because whatever has been claimed has been paid.
Okay.
I leave it to my Lord, man.
Okay. Okay, we will pass the order.
Yes, ma'am. Much obliged.
In reply to what the learned counsel for the appellant has stated, if I make a reference to para 257 of the judgment in Sivama, 257. At this stage, whether the merit of the case is to be considered or not is decided and discussed and decided by the Apex Court in 257. I'll not read it, Your Lordship. I'll just leave it to Your Lordships.
Okay.
Much obliged.
Item number 10.
My lord, this is also a POCSO case. I have taken steps upon the informant and it's not yet returned, so I may be granted some more time, my lord.
Heard, Mr.
Lalpian Fela Chongthu.
Learned counsel for the appellant, and Ms. Hambual, learned PP for the state respondent number 1. The learned PP submits that she may be granted further 1 week time,
2 weeks time, my lord.
2 weeks time, to ascertain service of notice upon the respondent number 2.
Yes, my lord.
Respondent number 2. Whether the record has been received?
No, my lord, it's not written in the cost list, so I believe it's not yet called.
Office note dated 17/6/2026 indicates that TCR has been received from the court of from the presiding officer, POCSO Act.
Item number 12.
Lordship, this is also a matter for condonation of delay, which has been filed by the applicants. Lordship, in last week, in Wednesday, this matter was fixed, but my learned friend, Mr. H. Gupta, has asked for a week's time, and today it has been fixed.
You have furnished the copy?
Yes, Your Lordship, he has got the copy on the day itself, and he was supposed to appear today, Your Lordship. It's through VC.
But not connected till now. Okay, we'll take it up after some time. Wait for some time.
Item number 13.
Yes, my lord, this is also a POCSO matter.
Okay.
The notice upon the respondent number 2 has not been received by the office.
PCR not received.
Are you appearing in this matter also?
Yes, my lord.
Part Mr. Swinson, learned counsel for the appellant, and Ms. Pambual, learned PP for the state respondent. Regarding, yes. So AD card has been received. Service was effected upon the respondent number 2. Where is the AD card? Where is the other file? The AD card dated 26/5/2026 indicates that the notice was delivered to the addressee, but no one remained present. No, but the respondent number 2 remained unrepresented today. And in that view of the matter, who can be appointed as legal aid counsel?
Legal aid counsel, I believe there's a list.
Pardon?
There's a list. List on it.
Can we appoint Mr. H. Zodin Sangha? Are you interested? Okay. Mr. H. Zodin Sangha is appointed as legal aid counsel to represent the respondent number 2. Respondent number 2. Office note dated 22nd of June 2026 indicates that TCR has not yet been received. Accordingly, the registry is directed to issue urgent reminder to the learned trial court for transmitting the record. List the matter in the next week.
Yes, after a week, yes.
After?
Next week, yes. After a week.
After a week.
Yes.
On 1st of July.
Yes.
Okay.
Oblige your lordship.
Item number 14.
May it please your lordship. My lord, this criminal appeal along with this IA has come up today for the first time. The IA is for condonation of delay of 287 days.
Yes, madam, can you represent the SI also?
Yes,
the
Your
respondent
Lordship.
number 2?
Yes, Your Lordship. Your Lordship, I would like time to file my objection in the IA.
Objection.
Yes.
Okay. Heard Mr. M. Biswas, learned counsel for the applicant, and also heard Ms. Kyangte, learned additional PP for the state for the respondents. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 287 days in preferring connected criminal appeal against the judgment dated 4/7/2025 passed by the learned Special Judge NDPS Act Aizawl Judicial District in session case number within bracket K 35 of 2023. Let notice be issued returnable. Can you file within a week?
Yes, Your Lordship.
Returnable on 3rd of July. However, no formal notice is required to be issued since Ms. Kyangte learned additional PP, entered appearance and received notice for both the respondents. The learned additional PP submits that she may be granted a week time to file her objection. We are allowed to recess the matter on 3rd of July.
I am deeply obliged, ma'am.
Item 15 to 16.
Yes, may it please your lordships. I am here for the applicants and yes, I'm here for the applicants appearing on behalf of the amicus, Mr. Joseph. And we are seeking for another time to file any objections in the IS. There are 3 IS actually. And I'm the petitioner in the main case, my lords.
Lordship, the earlier the learned friend has prayed for another time, so today also he has prayed for another time. So if your Lordship permits me, I would like to make my submission. Because it's a kind of unnecessary delay, because this coming monsoon there will be a problem, because my building permit will due to expire on 4th December 2026, my lord. So I have another 5 months only. So I have to construct another three-story building, my lord.
So are you really interested to file objection?
Yes, my lord. With that, we will try to make the exact current situation as soon as possible and to decide whether to file any objections or not.
My lord, the state has filed an IA application for construction in the month of April, my lord. And till now they have been asking for time to file an objection, my lord. I don't think they are really interested in filing objection.
Maybe for a last chance also, my lord.
Last chance.
Yes.
Okay. Let it be on 1st of July.
1st of July.
1st of July is next week.
But Ms. Pemble, learned. You are appearing in the capacity of?
Additional AG, my lord, for the
Additional
state
AG.
respondents.
In IA number?
IA number 65 of 26.
65 of 2026. And also heard Ms. Rosie appearing on behalf of Mr.
Joseph Lelson Himarentli.
And she prays for granting her further time to file objection. Taking note of the submission of learned counsel for both the parties, last opportunity is afforded to Ms. Rosie to file objection in this interlocutory application. Recess and release the matter on 1st of July.
Oh, yes. Deeply obliged, my lord.
Item number 17.
Lordships,
Yes.
this IA 121 of 2026 is an application for condoning the delay of 251 days in filing the connected appeal, Your Lordship, for the setting aside of the order dated 3/9/2025 passed by the single judge of this Honorable Court, Your Lordship. And I have formulated the reasons of the delay.
No, today we will issue notice.
Lordship,
on-
yes.
Heard, Mr.
Johnny L. Tocho.
Learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 251 days in preferring appeal against the order dated 3rd of September 2025 passed by the learned single judge in WPC number 75 of 2024. Let notice be issued to the respondents of opposite party returnable in. How many respondents are here?
Lordship, only one respondent, sole respondent.
7. Oh, sorry, one respondent. only.
One respondent.
Returnable on after vacation or
After
before
vacation, Your Lordship, yes.
After vacation.
Yes.
After returnable on 13th of July.
Lordship, yes.
July. Step be taken by speed post and also by usual process within a week from today. Additionally, dusty service is also permitted after effecting service of notice by dusty mode. The applicants will file an affidavit before this court. List on 13th of July.
July, Lordship.
So for item number 12.
My learned friend had joined earlier. Yes, talk to me on WhatsApp also.
Item 12.
Yes.
Yes. Lordship, my senior Mr. H. Gupta is in legs on another court. Lordship, another date may be fixed after vacation.
After vacation.
Your Lordship, this application has been pending since April of 2025, Your Lordship. And this is the third term it has been fixed, Your Lordship. We can take it up at 2, Your Lordship, if it's a number.
Today.
Today, Your Lordship. It's been pending for such a long time, such a continuation of delay.
Can Mr. Gupta appear at 2 o'clock?
Lordship, if they can fix a date after vacation, it's also acceptable to the other side.
The counsel for the other side has objection.
Lordship.
Your Lordship,
So let it be at 2 o'clock.
Okay, Lordship, I'll inform my senior.
Item number 23.
May it please, my lords. My lords, in compliance of the order dated 10/6/2026, my lord, the respondent number 7, we have filed additional affidavit giving the status report yesterday, my lord.
On behalf of the state respondents number 1 to 5, if I may be given another a week's time to file my status report.
I have no objection, Lordship.
Okay. Part, Ms. So-and-so, learned counsel for the petitioner. And Mr. So-and-so, learned counsel for the respondent number 1 to 5. 1 to 5. And Mr. So-and-so, learned counsel for the respondent number 6.
7.
Respondent number 7. For 6. 6. You have filed your affidavit? Okay. The learned counsel for the respondent number 1 to 5 submits that she may be granted.
A week's time. Additional for additional affidavit. Your Lordship, a 2 weeks time may be granted.
Price for granting her 2 weeks time to file additional affidavit.
Yes, Your Lordship.
Additional affidavit. Parallel, list the matter on after vacation.
So, Lordship, on 15th.
15th.
Yes, Lordship.
15th of July.
For hearing matter, item number 1.
Is the council present?
Government counsel is on leg in hearing in item in another
She's
court.
coming.
My
Lordship,
lord.
it's only 5 minutes and counsel just arrived. She might need some time also to reflect. Can we start after lunch? Lordship?
Pardon?
Can we start after lunch? Now it's only 5 minutes. The government
No
counsel.
problem, we can continue.
She just arrived.
We can continue for 15 minutes.
It's fine. All right.
My lord.
Yes. Yes.
My lord, in the last court that the issues to be considered is whether Kala is a competent authority for raising the petitioner's account or not. And the second issue should be whether tourism department has right to claim the compensation upon the period Patau which was registered in the name of the petitioner. And regarding the Kala is a competent authority for raising the petitioner's account or not is, I would like to submit that the land acquisition was acquired under National Highway Act 1956. It was acquired under National Highway Act 1956. Then if we have gone through the National Highway Act 1956, as per Section 3A, Kala was appointed as a competent authority. Then as per Section 3G, determination of amount payable as compensation. May I read out, my lord?
Yes.
Where any land is acquired under this act, there shall be paid an amount which shall be determined by an order of the competent authority. The competent authority had awarded me an amount of 37 lakhs 17,672 because all the assessment was taken in my name. Then if we go to Section 3H of the National Highway Act. Section 3H1, the amount determined under Section 3G shall be deposited by the central government in such manner as may be laid down by rules made in this behalf by the government with the competent authority before taking possession of the land. Then subsection 2 is as soon as may be after the amount has been deposited under subsection 1, the competent authority shall on behalf of the central government pay the amount to the person or persons entitled thereto. Then subsection number 3, where several persons claim to be interested in the amount deposited under subsection 1, the competent authority shall determine the persons who in its opinion are entitled to receive the amount payable to each of them. Then number 4 is if any dispute arises as to the apportionment of the amount or any part thereof or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction within the limit of whose jurisdiction the land is situated. Then the National Highway Act did not mention that the Kala has authority to freeze my account. Did not give any authority to freeze my account.
Yes.
Then in addition to that, that it is in page in addition to that, this National Highway Act did not
give authority to partition the amount after 3G award was ordered. 3G order was issued. Because of that, the Kala has no authority. The Act did not give any authority to did not give authority to the government to freeze my account. That is my first point. And the second point is whether tourism department has right to claim the compensation upon the PRD Pata which was registered in the name of the petitioner. And my first point is the tourism department had relied in the record note which was submitted by the affidavit in opposition submitted by the respondent number 4. It is in para 10.
Paragraph number?
Page 10 of affidavit in opposition filed by the respondent number 4. This document is also annexed by the tourism department in his counter affidavit. Page 10.
Yes.
If we have looked into this page, the heading is only the record note. It is not a meeting minute. If it is a meeting minute, that should be official and highly structured record used for legal compliance and historical accountable. But it is a record note. The record note means an informal, personalized, summarized, focus on capturing personal or team action items. If it is meeting minute, it should be entertained as a legal documents, but it is only a record note. Then if we get into the body of this record note, then in the second para.
Paragraph number?
Second para.
Yes.
Second para, may I read out, my lord? This is the English translation endorsed by the respondent number 4, Kala. The tourism department has established a structure on the property owned by Mr. Pilar Khamwana. It is acknowledged by the tourism department that the establishment of the land list of Pirdi Pata donated by Mr. Pilar Khamwana lack of formal agreement. Due to the absence of a proper agreement, the matter cannot be resolved at the Kala level and must therefore be addressed in the civil court. It is clearly mentioned that there is no formal agreement between the petitioner and the tourism department. If there is lack of formal agreement, there is a violation of Section 17(1)(b) of the Registration Act 1908. Then the next para. The compensation from period Pata 738 of 1976 to be provided to the tourism department will include payment for the structure fencing, RCC column fencing, RCC tanki, and RCC pavement. The remainder of the payment will be handed to the landlord, Mr. Pilar Khamwana. Given that this matter is between a private individual and the government, an affidavit is not required. This meeting minute will serve as the agreement, and a apportionment order will be issued accordingly. As per the section 17(1)(b) of registration N19 note 8, it clearly mentioned that in respect of the immovable property, there should be registered documents, registered instrument. But here also lack of registered instrument. This also clearly violates section 17(1)(b) of the Registration Act. In the absence of formal agreement and in the absence of formal agreement pertaining to donation, and in the absence of affidavit pertaining to the agreement pertaining to the partition of the land composition, there is grossly violation of Article 17(1)(b) of the Indian Registration Act, and therefore that the Tourism Department has no right to claim land compensation upon my Pidipata. I also would like to submit that if you go through the assessment report, all the assessment was taken in my name. As it can be seen that in my petition, page 24, 20, 22, 23, 24. Name of beneficiary is reflected. The name of beneficiary which is reflected is also my name. Then if we go to the additional affidavit submitted by the Kala, enclosure annexure number 1. If we look into the annexure number 1, the name of the beneficiary is also reflected my name. Name of beneficiary is also my name. Then I also would like to submit that if the Kala is self-accepted and recognized that the land which illegally occupied by the Tourism Department belongs to the Tourism Department, they should take different assessment. They should take different assessment, such as my name and the Tourism Department. But the Kala is self-considered and agreed that the land which the Tourism Department occupied belongs to me. Because of that, all the assessment was taken in my name. There is no picture of the Tourism Department in the assessment record and in the notification which was issued under the under National Highway Act. How can they claim that it belongs to me? They have no right. They are illegal occupation, and they have no right to claim compensation upon my land, even if their structure is standing thereon in my land. Because they are illegal occupant.
Okay.
Then the order dated 22/3/2024 had allowed me to operate my savings account. Then we can operate by savings account. And my pleadings is also to unfreeze my account. And this is my pleading. And it becomes, since 22nd, 2022, 2024, it become infractions, and therefore I pray to this honorable court to allow me to withdraw of my petition.
Pardon?
To withdraw of my petition. Because everything is becoming infractions. My pleading is to unfreeze my account. And I can operate my account.
Now you want to withdraw this petition?
Yes, my lord. Because it become infractions.
Yes. Respondent number 4.
Yes, ma'am.
Lordship, can I start after lunch?
Okay.
If I may permitted to make a submission, is one line only.
Pardon?
I'm for Union of India, respondent number 3. It is admitted that the award had already been paid to the through the DC, my lord. There is no issue with regards to Ministry of
All
Road
right.
Transport and
All right.
Highway. However, my submission may be reflected in the order. That's
Okay.
much, my lord.
Okay.
Obliged. Then the same has been admitted in para 4 of the writ petition also. That much. Thanks.
Yes. Respondent number 5.
Fine.
Yes.
My lord, I'm for tourism. I'll start from afternoon because we are the main aggrieved party in this case. Tourism department.
How much time you will
I
take?
think might be 30 minutes.
30 minutes.
Yes.
My lord, it is unfair because we have around 8 minutes.
Pardon?
We have around 8 minutes before going for break. Then he can have a submission before that.
No, you see, now the petitioner want to withdraw the petition.
That's the court also objected. Justice Michael did not allow and it's very strong word and
Earlier.
yes, earlier also even it was also there. Even there is live stream also, and we really strong object after getting the amount and after using. In fact, I think government council also inquired. Now the money is only now 1,000 or something now. They have taken all the money.
My lord, when
They
Mr.
cannot
Justice
block it
Michael,
and call at the same time.
my lord, when Justice Michael he objected my submission regarding the withdrawal, that day I was not allowed to make a submission because of that.
Justice Michael
If
actually really.
if I can say something and if I can say if I can express the fact of the case, then Mr. Justice Michael won't be objected my submission.
Anyway, now we are not concerned with that. So you want to argue the matter after?
After lunch, Lordship.
Okay. So after at 2 o'clock, we have one division bench matter. It may take 5 to 10 minutes. Thereafter, we will resume.
Lordship, that's fine.
Yes, anything from the respondent number 4? Affidavit.
Assessment was made in the name of the petitioner.
Yes.
Basis of the report.
Yes.
Not record this letter, my lord.
And I have one citation with regards to the motive of the relief by the report. However, the report will go beyond for your opinion.
Okay, so you furnish it to the court master.
My lord, I would also like to make a submission for respondent 1 and 2. We are bank appearing for respondent 1 and 2 for
You also want to make submission.
yes, my lord.
Okay.
Reload this.
In the second half, we will continue. Okay. So, madam, your part is over. You have nothing to submit more.
She have submitted that their part is just to unfreeze the bank. They have represented the bank, so they do not have any other submission other than that.
Okay, all right.
And that there is no amount, no, in the they were instructed to get the details of the account amount which is lying in their account, and it was informed in the earlier earlier dates.
Yes.
And my submission will be only to the content of the record notes. On the basis of that, we have made the assessment. That's it.
Okay, all right.
And I am relying in paragraph number 25 of the judgment, wherein admittedly the facts of the case is different, but then I'm taking the ratio dissidenti in this case. Great court have the power to hold the relief, even though a prayer is not made.
Okay, we'll see. So counsel for the applicant is absent.
Your Lordship is present. Your Lordship, he has joined the computer. He has joined the computer.
We have not seen him in the screen. Mr. Gupta?
Lordship, my senior is on legs.
No.
Item
During the first half, we have asked you to tell him to remain present in the court at 2 p.m.
a different matter was
Then what to do?
Your Lordship, I will have to pray for dismissal of this.
Lordship, a different matter was called for
Because
in the Gauhati High Court.
I've messaged him. We've talked to each other during the break, and he knows very well that he has to appear. And my Lord,
So we are dismissing the application for condonation of delay. Or you can argue the
Lordship, please
matter.
chance may be given.
No, specifically asked him to be there, he should have been there.
No, in spite of specific direction, he remained absent. You argue then.
Lordship, I am new in this chamber. Lordship, please, a date may be fixed after vacation. I'll make sure that my senior is present on that day, and
But
the matter is heard.
we will grant you adjournment subject to payment of cost. Are you ready to pay the cost?
Lordship, I apologize that he is not being able to be present right now.
No, this is not the way.
Your Lordship, in the for the last court date also, it was
The
fixed.
last
That
chance may
was
be
fixed-
given then on the next occasion.
No.
That was fixed on my learned friend's prayer. And in the last court date, Your Lordship's prayer here, he again asked for this adjournment for today. And this is Your Lordship third time. Your Lordship, his submission, his application is there, and my reply is there, Your Lordship. And if Your Lordship will allow me to continue, I can continue. And if you don't want to appear, he's playing hide and seek with the court. And Your Lordship, he has filed this application for seeking 660 days delay. And he has filed this on 4th of April 2025. And he has given me the copy of this only in October. So this has been a tactic going on, not in this case, Your Lordship, by Mr. Gupta, Your Lordship, in another case also. See, after 660 days, he has filed, and he don't want to hear the hearing even after 1 year after the filing, Your Lordship. So the delay is very huge, and on top of that, after filing also, another delay of more than 1 year. And we have got the judgment of the single judge, which cannot be acted upon, and this is a denial of justice, Your Lordship. And he has specifically known, we've talked on the WhatsApp, that he knows that Your Lordship says that you have to appear at 2 o'clock. This, Your Lordship, this is, I'm praying for Your Lordship for dismissal of this. Or otherwise, Your Lordship, if you allow me to argue, I'll argue on my part of the.
Okay, you argue on your part.
Yes, Your Lordship, I have made, for Your Lordship convenience, I have made a summary of the points so that it will be brief for Your Lordship. Your Lordship, I have written the points of argument, Your Lordship. If I may proceed.
Yes.
WPC number 47 of 2023 was disposed by order dated 15/5/2023, passed by the Honorable Single Judge granting interest under Section 28 of the Land Acquisition Act 1894. Writ appeal have to be filed within 30 days, that is on or before 13/6/2023. At part 2 of the instant application, it is admitted by the applicants that certified copy of the order dated 15/5/2023 was received by the General Manager, NF Railway, that is the applicant number 2, as early on 6/6/2023. However, the connected writ appeal was filed only on 4/4/2025 after a delay of 660 days. Counter to the reason for delay mentioned in the IA. Point number 1. At part 2 of the application for condonation of delay, the applicants claimed that the huge delay was caused due to, quote, administrative and other difficulties within the department, end quote. However, there is no document brought on record to substantiate this claim. There is no explanation of what is meant by administrative and other difficulties. It is humbly submitted that this is nothing but a vague excuse and not an explanation within the meaning of sufficient cause for filing the appeal in time. Point number 2. At part 3 of the application, the applicants admitted that the law department sought for legal opinion from the Central Government Council regarding the order dated 15/5/2023 in WPC 47 of 2023, white letter dated 12/4/2024. This means the legal opinion whether to file an appeal was sought by the applicants from their council only after more than 324 days, almost 1 year, from the date of passing of the order by the Honorable Single Judge. The applicants have not given any explanation of what they were doing during these 334 days. This clearly shows that the applicants have no respect for the order passed by a constitutional high court of the country. Furthermore, after legal opinion was furnished to the applicants by the council white letter 14/4/2024, the appeal was actually filed on 4/4/2025. That is after further delay of 356 days. This clearly reveals the applicants have been negligent, indifferent, and lethargic at every step of the way pursuing their appeal. Point number 3. At paragraph 4 of the application, the applicants have stated that, quote, certain relevant documents relating to the case file was misplaced and could not be traced, due to which the preparation for the appeal and filing the appeal got delayed, end quote. However, the applicants have not cared to apprise this honorable court what are the relevant documents which were allegedly misplaced that prevented them from filing the appeal in time. There is also no mention on what date on which such relevant documents were eventually recovered and sent to the council. It is submitted that these statements are vague excuses and not sufficient explanation for condoning an inordinate delay of 660 days. Further, the documents annexed in the connected appeal are judgments and orders, and some documents readily available at the registry of this Honorable High Court and in the office of the concerned district collector. Point number 4. In response to para number 6 and 7 of the present application, it is humbly submitted that the question raised in writ appeal, Your Lordship, this part, I'll just, before this, they say in the application that there's a similar matter pending before another court. So that is why the condemnation of delay should be condoned and appeal heard. So, in response to the para 6 and 7 of the present application, it is humbly submitted that the question raised in writ appeal number 8 of 2024, re-registers at WA 383 of 2025, is not the same with the instant case. The landowners in WA 8 of 2024 have been paid interest under Section 34 of the alia Act, and they are claiming additional interest under Section 28 of the alia Act. In the present case, the landowners have not been paid any interest either under Section 24 or Section 28 of the alia Act. Further, writ appeal number 8 of 2024 was admitted since the delay was only 34 days. This order of condonation, Your Lordship, we have annexed herein. I'm also the counsel in that case, Your Lordship. That is why I know the facts. In this connection, the Honorable Supreme Court in Brijesh Kumar versus State of Haryana, 2014-11 SCC 351, para 11 has laid down that if some person has obtained a relief approaching the court just or immediately after the cause of action arises, other persons cannot take the benefit of the same by approaching the court at a belated stage simply on the ground of parity, equity, sympathy, and compassion. Similarly, in the state of Karnataka versus S.M. Kochaya, 1996, 6 SCC 267, the apex court has held that relief granted by the court in a similar case cannot furnish any ground for ignoring delay and laches. Point number 5, Your Lordship. Contempt case number 5 of 2024 was filed before the Honorable Single Judge on 22/3/2024 for non-compliance of the order dated 15/5/2023, passed in WPC 47 of 23. Office Note 2026, Office Note 26/6/2024 in the said contempt case indicated that notice were duly received by the present applicants number 3, 4, and 5 on 12/6/2024, and ID card returned on 26/6/2024. Notice in respect of applicant number 1 was delivered on 10/6/2024. In spite of the fact that the present applicants have been aware of contempt petition filed against them, in which they have contested through their counsel. This part, Your Lordship, is important. It is admitted by the applicants at para number 8 of the present application that they decided to file the appeal only on 25/1/2025, after order dated 21/1/25 was passed in contempt case number 5 of 2024, by which time there was already a huge delay of 592 days. Thereafter, their counsel took another 69 days to finally file the appeal on 4/4/2025. This clearly serves to show the applicants have been deliberately sitting on the fence with attitude of utter indifference, callousness, and disrespect for the order passed by this honorable court. Hence, they are not entitled to exercising of the discretionary power of this honorable court in their favor. Last point, Your Lordship. The order dated 15/5/2023 in WPC number 47 of 2023 sought to be impugned was passed by the Honorable Single Judge as the matter was squarely covered by a similar case earlier disposed by order dated 25/10/2022 passed in WPC number 115 of 2022. We have annexed this as Annexure 1 and 2 of our written objection, which has already been complied by the present applicants and payment made by them. The matter in these two writ petitions involves payment of interest under Section 28 of the alia Act, arising out of the same land acquisition proceedings, located at the same stretch of land, in the same village, and covered under the same award passed by the District Collector Collection. In fact, the learned counsel representing the present applicants in WPC number 47/2023 fairly admitted that the case was a covered case, and as such did not raise any objection in the writ petition. So, Your Lordship, this is very clear that if we go through their application also, which we have highlighted, they have admitted that they made a decision to file an appeal only on January of this year, or January of last year, 25/1/25, by which time there was already 592 days of delay. And they have admitted they seek legal opinion after the expiry of 334 days. Legal opinion whether to file or not was asked by a letter after 334 days. They have not explained anything what they have done before this, Your Lordship. And the only reason they have given was administrative difficulties and some misplacement of documents. Nothing. What is administrative difficulties? They have been facing for more than 600 days. They have not explained that. What are the documents they needed? They have not explained that. So these are just vague excuses, Your Lordship. And further, Your Lordship, before filing of for the expiry of the period of limitation, they have not explained anything on that part. What were they doing? No explanation was there. They only admitted that we received the certified copy of the order before the expiry of the limitation. It's like they're shooting themselves in the foot, Your Lordship, admitting everything in the application.
Okay. Yes, Mr. Gupta.
My lord, in this matter, my lord, in fact, similar issues are pending before the principal seat, my lord.
Mr. Gupta, tell us one thing. I mean, there was a direction given by these division bench to you to be present before this court, and you were not there. Your junior was there, and before and without apologizing, you started arguing your case. What kind of behavior is this?
I'm sorry, my lord. My lord, I was on legs, my lord.
No, whatever it may be, you can't
Lord,
you can't do that.
I'm
this
sorry,
like
my lord.
that. You can't do this like that before a division bench.
I'm extremely sorry, my lord. I apologize, my lord. I apologize, my lord. Didn't mean it. My lord, the issue, my lord, but in this matter, my lord, there is some development, my lord. This pertains to, my lord, payment of interest under both the sections, my lord. Here and, my lord, in Mizoram, there are several writ appeals pending, my lord, before the principal seat on the same issue. And in this matter, my lord, the claimant landowner has sought for interest under one section. So, my lord, here the department is contemplating to pay that interest, my lord, since they have sought it under one section. But the issue is, my lord, in other writ petitions, similar landowners are claiming interest under both section 34 and section my lord, 28 of the Land Acquisition Act
Yeah, are
in
you arguing,
1984. My lord,
are you arguing in the merit of the matter?
no, my lord, I am just praying, my lord, that some developments are there, my lord. We may we may withdraw the appeal also, because the issue here pertains to payment of interest only under one section, whereas my lord, on the similar issues are pending before the division bench. My lord, there are series of matters in which my learned friend is also there, and it is fixed tomorrow. That matter is fixed tomorrow, my lord, before the principal bench. Similar issues, my lord.
If I may, Your Lordship, the matter is not similar in the fact that here,
Similar
just,
matter, my
my
lord.
friend just stated,
Payment of interest under both
this
sections.
case is, even though this, Your Lordship, this judgment says that the merit of the case cannot be looked into at the stage of condonation of delay. And I have two judgments here, Your Lordship. I'm going to produce, Your Lordship, if Your Lordship will grant me. Firstly, my Lordship, the matter here in this particular case, it's only regarding section 28 interest, which similar persons, similar, everything similar from the same village, my neighbors have been paid by them. So we are coming after them, same order, and say that this is a covered matter. Everything is similar, same transaction, same village, same land. My neighbor is getting, we come to the court with a writ petition saying, and we've given all the documents. Everything was perused, and the learned counsel appearing for, not Mr. Gupta, the learned, another CCC appearing before the learned single judge, perused the document and submitted that, yes, it's a similar matter, same to same. So order was passed. Now Mr. Gupta has come after 300 days and saying, we're going to file an appeal. But the similar case has been paid, which is not disputed by them. And we have, Your Lordship, we will just see by affidavit in opposition the payment made. The payment letter is there. Everything is on record. Everything is same. My neighbor is paid. I'm not paid.
No, okay.
And the matter which is pending there in the division bench, which
Mrs.
is saying,
To that aspect only,
there
my
is
lord,
a
I
different
submitted
matter
that the
No, no,
department
in
is
the sense that whether
contemplating to.
two sections of
Mr.
under two sections can be paid. That is the question there, not here.
Mr. Silo, we are not concerned with the merit of the matter. We are concerned with the ground of delay. Mr. Gupta, you explain the delay. Mr. Gupta, you explain the delay.
My lord, I am little today, my lord. This matter, my lord, I could not skip the, my lord, my attention, my lord. My friend informed me, my lord. Then only I have joined, my lord. I was praying for a
On
small
the other
accommodation, my lord.
day, with your consent, we fix the matter today.
Yes, my lord.
Now you cannot turn around. You
My
argue
lord,
the matter.
I skipped my matter today, my lord. The file is not with me, my lord. Can I pray, my lord, for tomorrow, my lord, if my lord
No,
agrees, my lord? Tomorrow, my lord.
tomorrow it is not possible. Better you send your written argument. We reserve the order today. Heard Mr. Gupta, learned counsel for the
My
applicant,
lord, for
and
tomorrow.
Mr. Silo for the respondent. Argument concluded. Order reserved. However, Mr. Gupta is granted liberty to file written argument in this matter, and the same shall be filed within tomorrow.
My lord.
By tomorrow, you file the.
By tomorrow.
Okay. Argument or
I'll file.
order reserved.
Public.
Hearing item 1.
Yes, respondent number 5.
Yes, Your Lordship, I am appearing for Tourism Department. Your Lordship, just before going to my own submission, allow me to go to my version, just only some 5 minutes. If you kindly have my counter affidavit, so very brief fact of my case. How this dispute came into being. My lord, you're there? My lordship. So, my lord.
Yes.
Yes. So this is how it started. The story started. I would like to take you to page number 11. 11. My lord, there is central scheme from Ministry of Tourism. So there is a project called Tourist Destination at Labung. That the amount is 484 crore project. So there inside that, there is the tourism department, that tourism is just the border with Bangladesh. So there, for construction of tourism also, that the amount is earmark is 2 lakhs. So then it is on 2021. This project started and they sent a letter to Tourism Department. So then this project concept paper was presented and DPR everything. Then on 2013, after 3 years, if you kindly go to 14, page number 14. So then we started and we issued this project for constructions of the project from work order tourism destination to Lusai engineer on 2013. Then they started construction and we finished the tourist lodge. Not only the tourist lodge, there was another cafe or some other things in around that. So before that, admittedly, and also we all admitted that because in this kind of project, there is no money for this acquisition compensation at all. So somehow the department, in another project, tourism department project also, so it's a kind of donation, they donated and we paid some amount. That time they admitted that 10 lakhs was paid before constructions of this development of the project, tourist destination at Labung, and that 10 lakhs, without any objection, without any protest, he received and we started construction. Work order was issued. Construction started. People enjoy from foreign, from abroad, they came, they enjoy a lot. No problem at all. Then this project, widening of National Highway started coming on 2011. That time, even tourism department, some of our tourists also still in the names of other private person. Some VC pass also now in some other places in Mizoram also. Now, recently we started trying to have as this thing land lease. And now we took step also. But some other things, there's some problem because their father, grandfather passed away. Their son somehow, they object, they are asking money and something we started facing. And here also, before 2011, before this project, extension of National Highway came, we had never any project, never disputed anything, never claimed anything from their side. Then, when this project, National Highway came, and spot verification we are trying to have, we applied for land lease. Then, even this letter also very clear, she also read out, she admitted, page number 15.
Page number?
It's 16 is the English translation.
Yes.
Here, one fine morning, we are trying to demarcate for issuance of land lease. So even the petitioner and her wife was also present at the spot. Surveyor from Land Revenue Department, the one who was going to demarcate, also present. And our representative was also present. But that time, the petitioners make up another story. That 10 lakh was not a sale deed. It was only for site development. Because that is Justice Michael was very annoyed and very angry. How could it did this 10 lakhs you accepted? How can they develop your site project is what that the councils asked. That 10 lakhs I don't know, we never know. We will not, even a prudent layman will not understand that these 10 lakhs will not pay for their site development. It was for the constructions of tourist lots. We constructed, we enjoy, and in the surrounding area also, we developed so much that they never objected. Then on 2011 and 2012, then that new story came, 10 lakhs, they received, they admitted it was for site development. Then the surveyor refused to take up the measurement, then he went home. That is what it is there on 2012. Then Annex 4, my lord, because this National Highway Act, this compensation was governed by National Highway Act 1956. So that the process is that my learned friend also read the act, everything. This is 3G, 3H, it's there. Here, this is Annexure 4 is, actually this annexure was, I have taken from their petition itself. They enclosed this petition, this annexure as Annexure 1. This is their annexure also. If you kindly read, this is estimate for acquisitions of land. And this periodic pata, name of the past, because it was not still in the name of the petitioner, land lease was not issued in favor of tourism department. If you see this one, amount, the trees of crops, the numbers of trees, 11 lakhs. 11 lakhs, that we did not dispute. 11 lakhs, there are some standing crops, some mango, some other things are there. And another here, if you kindly read the structures, 7 assets, the structures. This is 7 lakhs. Lordship, you're there. Annexure 4.
Got
There, if you go to the next one, page number 18. Here, assessments of RCC, semi-RCC building. Land acquisition, widening, upgradation of national highway. Here, very clearly that it is written RCC, RCC1, RCC2, tanki, column, fencing, pavement. It was assessment was done, and altogether, this is 7 lakhs, 90,000, almost like 7 lakhs. So what is undisputed fact is that it was still registered in their name. We occupied, we constructed tourist lodge, and just near to tourist lodge, not now tourist lodge is still standing, but the compound near our tourist lodge, still there is a column, pavement, fencing. That require that to be assessed. Then the government, for widening of the road, they require it. Then assessment, that part was taken. That is 7 lakhs. Then around that, within that periodic pata, that is a very big land. In fact, periodic pata, it is very settled law that periodic pata did not give absolute right to the owner. It was only the land of the government use only on some terms and conditions. I'll not go into that periodic pata.
No, Mr. Counsel, you cannot advance that kind
Malo,
of
that,
argument.
no, I just want to say it's a very big periodic pata. No, just fact
So,
is that,
you see, you have no document to
Yes.
show that your name is there.
yes. So my lord,
Admittedly, the award was passed in the name of the petitioner.
yes, yes. And my lord,
The
but the
compensation was
building,
awarded in the name of the petitioner.
but the building, the tourist building, column, the pavement, everything, it was there in the 3G estimate of the building compensation also. This is the law that the court also directed on earlier occasion to clarify Kala, that 37, how demarcation, apportionment was made. Also that in the last occasion, I submitted this. My lord, this is my story. Then my lord, then 3G estimate was come. As per the law, if they dispute that 3G estimate, they have to go to arbitrator appointed by the government. That is the process is there. But Annexure 5, there was some dispute. Without going to arbitration, without going to the court, and that Kala, because Kala is the competent authority as per the law. This is the Kala. Kala conducted hearing, and this is record note. They say that it is nothing, it is, but record note is a kind of decision
The
making.
minutes of meeting.
Yes. Here, everything, the decision is there. Page number 24 is the English version. I'll just brief up. That is that the whole land was in the name of the petitioner, and the land was acquired and construction was made by tourism department. Here specifically it is written that the column, The pavement, the fencing, RCC was done by Tourism Department, and the remainders of the payment will be handed over to the landowner. And for this, the cost of that fencing RCC should be Tourism Department. It was clearly specified in this Kala decision on 17 of November 2023. And 2022, my lord, this was attended by Kala, by tourism representative from Tourism Department, without any protest by the petitioner himself also. He put his signature also. If you kindly see 25, page number 25, serial number 7 is the petitioner. So no dispute at all. My lord, that's 7 lakhs. If it comes under this act, solution is 100%. It is the double, and my lord, their part 11 lakhs. It is double. Altogether, exactly 37 lakhs. No dispute at all. Very nicely, mathematical precision calculation was made by the Kala. Because that 100% is just the double. That is 37 lakhs. It has to be a portion only. And my lord, my fact is that is my story. And the petitioner filed a case. So very short petition. Only 4-5 para. I think 6 para only. The long and short their petition that they in fact they did not include the Tourism Department at all. First is that there they claim that they are absolute owner of the land. They stated that with the periodic pata, and they did not say anything that Tourism Department was there and that they constructed the land. And 3G estimate was published. Then third para. Then they enclosed the one I have furnished also. If you closely, that I have taken from their petition, if you closely look at their petition also, this is their annexure. It is written very clearly, the column, the fencing, everything. And number 4 para is that I am suffering from such and such. I cannot operate my bank. I cannot use my account. That is what they said. And I inquired to the bank, and I came to know that on 22 May 2023, the Kala had sent a letter to defreeze. If you kindly see, my lord, their petition here at page number, this is the letter 22. 32A. And just before that, if you want to see their petition itself, from 22. This is their petition, 22. This is survey report. Even survey report also, and 23. Here are all mango, guava, the numbers of trees. But if you look at 24, you'll see again RCC tanki, RCC column fencing, and RCC pavement. This is their petition, 24. And the bank account, and my lord, it is very clear from 28A. Are you there at 28A? My lord, here 24 and 26. Here RCC building, tanki column, the amount was also, assessment was also made. See exactly, if you see 26, that is 7,09,746. 26. 26, serial number 185.
Yes.
Yes. Thank you, fencing. And amount was mistakenly transferred on 14/2/2023. If you see 28A, on 14/2/2023, see this amount, 37 lakhs.
Yes.
My lord, if you want to see this account, see, 14/2/2023, they keep using the money. If you just see, just below that, 5 lakh was withdrawn, 3,50,000 was also withdrawn, 3 lakhs was withdrawn. By check, they were able to utilize this amount, this money. They have been using the money. And my lord, what is very important here is that the letter sent by Kala, it is at 32A. My lord, in that 32 is the bank letter sent to the petitioner. And here, better to read 33 first. It started from this 33. Annexure number 7. Can I read, Lordship?
Yes.
Very short. To Chief Manager, State Bank of India, Tlapung. Request to hold account number such and such. Sir, with reference to the subject cited above, I have the honor to request you to freeze transaction of the State Bank of account number 33 such and such in respect of P. Lalkhamwana, as the account was mistakenly credited full amount of 37,17,672. The full compensation amount for acquisitions of National Highway 302 project has to be apportioned between P. Lalkhamwana and Tourism Department as per enclosed meeting minutes. My lord, if you kindly look very closely that what was freeze and which amount was on hold, it is very clear in respect of P. Lalkhamwana, as the account was mistakenly credited full amount of 337 lakhs. This is, they request only this transaction of 37 lakhs. The bank, Kala, requested to freeze the transaction of this 37 lakhs only. In other terms, they call on hold. Sometimes they use the terms of lien in some because generally we use freeze. But that, that another language we use it also on hold and freeze also. But they request only 37 lakh. This is the disputed amount of compensation to be apportioned between Tourism Department and the petitioner, as enclosed by the meeting minutes 17 November 2022. And they inform the petitioner. We'll go, if you go back.
Mr. Counsel, you see, though in Annexure 10, the minutes of the meeting.
Okay, 10, yes.
The petitioner has put his signature.
Yes.
But can it be said that he agreed to the aforesaid minutes?
My lord, the law in respect of compensation, normally they put signature protest sometimes, and they refuse to put their signature also. On protest also they sign. And my lord, my point is that in this case, if they disputed this order minutes, they should have challenged this November 17 November 2023. They are never aggrieved. They have not pleaded also. They hide it. That's why they approach this honorable court with unclean hands. They all hide material fact that Tourism Department is the aggrieved party. They did not include also. And my lord, moreover, one very important is that they did not aggrieve this meeting minute. Again also, very interestingly, 22 May 2022 order or letter by SBI was never challenged. Freezing of that transaction of 37 lakhs was never challenged. So my lord, my submission, my point is that.
No. Freezing of the bank account has been challenged.
No, they challenge only, generally, if you kindly see their prayer, your lordship, kindly see page number 7. para number 10. May I kindly read? Your Lordship may graciously be pleased to admit this writ petition, issue rule directing respondents to show cause as to why petitioner personal SBI account such and such shall not be unfreezed. After hearing the case that may be shown by the respondent, your Lordship may please to make rule absolute. See, my Lord, very general, very vague prayer they pray that why the account of this should not be unfreezed. My Lord, the law is very clear, very well settled. Freezing of the account, the bank account is the personal property of individual. It cannot be freezed. It is violations of the fundamental right of the person. It is, we admitted that. But what is the law? Times and again, the Supreme Court, High Court also, they pass many orders that freezing of the account violates a fundamental right, but disputed amount of the property, it can be on hold. They are trying to show that they freeze all my accounts, I suffer, and my right has been reflected. But in their prayer, they did not mention that compensation amount, 37 lakhs, is the main money that they are trying to get. They have not prayed for. They have not prayed for that.
They have enclosed the assessment or the notification of the central government published in the official gazette. They have also shown the assessment in their name.
They enclose it, but here they have not made any prayer, specific prayer. They have not prayed. And my Lord, let me finish first. My Lord, they just say that they are trying to show that it was our money. They did not say that it was construction, that estimate from the tourist lot. They did not say that. But they just try to impress and try to show that without impeding the tourism department. And though their main prayer is that it looks like for the freezing of the account, but their main prayer is that for taking out of the disputed amount 37 lakhs. It is true. And interim they pray that, then the court released it before we came into this picture. Then interim order was prayed, but undertaking was given that it will be returned back when adverse order was prayed. My Lord, the law, I can produce that. My Lord, here, though their prayer is that for the freezing of the account, their real intention is that to get the money, that 37 lakhs. It is very clear. That is disputed questions of fact. That way, I object that their fundamental right has not been violated. They can use their account, my Lord, except that 37 lakhs they cannot use. That is disputed questions of the compensation. I can give the judgment passed by High Court also. My junior will hand it over to you. The High Court also passed by Jharkhand, also by Rajasthan also. Then holding of the account is fundamental right, except that they can hold the disputed questions of money. And I'll take you to one is Rajasthan. Here I have taken from Life Law. The heading itself is banks can freeze only disputed amount, must allow customer to operate the rest of the account. Rajasthan High Court. Just to understand the case, I just put that Life Law publication, and that the judgment is just next. Here, very short judgment on 27/11/2025. The same prayer here. Here the court is that having considered the fact and circumstances of the case, the court deemed fit and proper to dispose of the petition with the direction respondent number 2 to keep the disputed amount, the amount which was transferred illegally in the bank account, frozen, and allow the petitioner to make transaction from his bank account from the remaining balance. My Lord, next one is very recent one. This year, 2000 March. My Lord, that is Jharkhand, Telangana, Hyderabad. Relevant is from Para 7. This court is the opinion that keeping on the disputed amount on hold would serve the interest of the parties.
Yes.
My lord, here my point here is that they are trying to look as if they are praying for defreezing of their account. No objection. But they did not inform the court, they did not make a prayer for setting aside of the impugned letter, also actions of the Kala also. And also, in fact, behind that, what they are trying is that they are trying to have that 37 compensation amount will be jobless, will be remedialess, my lord. Because we are the one who constructed the tourist lodge. It is our money, and then
No, the problem lies upon you because without any documentation, you have occupied the land.
my lord,
Without any documentary proof, you have paid the amount of rupees 10 lakhs.
my lord, that is questions of fact. Then under Article 226, the court should not much interfere. I also have furnished also because this regarding donation, regarding this thing, they file civil suit during pendency of this case before civil judge. Then they challenge also, and they challenge that construction, and now they pray for compensation, they pray for eject. In fact, they pray for eviction, but they amended, they say ejection. And then they are trying to eject us. That is, civil court can decide. But as of now, in respect of this case, it is freezing of their bank account.
Yes.
Yeah, in freezing of bank account, the law passed by High Court is very clear that it is violation of their fundamental rights. If it is, the whole is clear, but disputed amount should be kept on hold. But so High Court under 22 should not take into the disputed questions of fact. My lord, I have furnished two judgment.
No, that is a well settled proposition
Yeah, that's
of law.
definitely, my lord. But my case here, I have given to you is that exactly regarding the questions of amount of money. Because some other thing is that regarding payment of money, but there is that the questions of money. My lord, my is that, my lord, I don't, if the lordship, that government council also submitted that under 26, this question is very vast. If they are agreed that as per the decision, as per their own annexure, it can be distributed very fairly. They can have that damage compensation assessed under 3G, that amount 14 lakhs plus 100%. And we can get for the tanki, the loan, that 7 lakhs, that is 14 lakhs. It can be distributed. Well, that is
No, where is the proof that you have constructed that that fencing, that pavement,
my
and
lord,
the tanki?
my lord, from their annexure itself, see, if you kindly see 24. 24, page number 24. Their petition, annexure 3.
Yes.
Here, if you see,
name of the petitioner
well,
is there.
no, they take it as if that the owners of the periodic pata. But here,
Periodic patta is there. Number of the periodic
yes,
patta
Balot,
is
we
there.
admitted that it was still registered in their name, but this is, they never disputed that we constructed tourist lots within their plot of land. This is tourist lots, here RCC tanki, RCC column, fencing, RCC pavement. And even the amount is also, year of completion is also there, 2017. This is their documents.
No, they have enclosed this document
Yes.
with their petition, that's all right. But can it, going through this document, can it be said that you have constructed this?
My lord, their document itself, they stated that they constructed tourist lots within our land. Even their additional documents, everything, they submitted that. There is no disputed that we constructed the tourist lodge.
whether in their writ petition they have stated that
No,
it was
in their,
constructed by you.
in their petition, they kept silent. They hid all material fact. But if you kindly read their rejoinder affidavit, which was filed on 25th 9, 2025.
Yes.
Here, from para 2, with the statement in respect of statement made in para 4 to 7 of additional affidavit, I would like to submit that respondent number 4 submitted in his additional affidavit that the portions of the petition affidavit pata was bought by Tourism Department without formal deed as mandated. Respondent number 4 further submitted that construction of tourist lodge was completed in 2017, but partition and mutation was aforesaid land was not completed in the 2021 when notification for acquisitions of affected land by National Highway construction project was notified on 22/11/2021. In fact, when government possess or occupy the private land, the government shall acquire such land with due legal procedures of land acquisition, failing which it should be considered as illegal violations of personal right to property guaranteed under 300A of the Constitution. In the case of the petitioner, his land was occupied by Tourism Department for construction of tourist lodge. So it is admitted that we constructed tourist lodge without executing any formal sale deed between them as mandated, which caused to restrain Tourism Department from partition and mutation of the aforesaid land. Such occupation is illegal and unauthorized as per law. It violates the petitioner's right guaranteed under such and such. Since Tourism Department was illegal and unauthorized occupants, their name was not reflected in the entire notification which was administered by respondent number 4 at the time of acquisition process, so that compensation was determined in the names of the Tourism Department under section 3G of the National Highway by respondent number 4. Hence, the department was entitled to receive any compensation since Tourism Department had willfully, illegally occupied the petitioner land. His daughter, namely Lalzompui, who inherited periodic pata by virtue of heirship certificate, filed civil suit 11/2025 in order to retain the possessions of the aforesaid land from Tourism Department as the illegally and unauthorized occupant by order number such and such. My lord, here my submission is that it was not disputed that we constructed tourist lots within their plots of land, and they filed a civil suit also for eviction compensation also. So my lord, here as of now, my landed friend read that the act. My lord, allow me to read the act 3A. I think it's with you right now. The
No, not
National
necessary.
Highway-
We are
My lord-
mainly concerned with the unfreezing of the bank account.
Yes, my lord. My lord, the act is very clear. Authority was given to Kala because the action or the step done by Kala was as per the act. There was no illegality in requesting the bank. Allow me, my lord, read only 2 para, 3H. My learned friend just read only 3G. 3H is important. 3H of National Highway Act.
Where is that?
Three H. My lord, 3H is the 3G estimate was done. That one is that we enclose the 3H deposit and payment of the amount. The amount determined under 3G shall be deposited by the central, in its opinion, are entitled to receive the amount payable to each one of them. Number 4, if any dispute arises as to apportionment of the amount as any part thereof or to any person to whom the same or any thereof is payable, competent authority shall refer the dispute to decisions of the principal civil judge of original jurisdiction within the limits of whose jurisdiction is situated. Number 5, where the amount determined under section 3G by the arbitrator, that is arbitrator, it was not decided by arbitrator. My point is that while deciding the action taken by Kala was not challenged inasmuch as it was as part of law. And they have not challenged it. There is no violations of the fundamental rights of the petitioners. And my lord, that the bank requests only to keep on hold, to freeze only the transactions of 37 lakhs. Where is any legality in holding, in freezing 37 lakhs? I do not object to unfreezing of their account as prayed for. That's plainly prayed. But their prayer is not.
You see, the amount has already been withdrawn.
No, no, subject to decisions of the court, and they have taken undertaking that they shall return to the court or to the bank. Because that time they stated that we badly needed, that we are in hospital, that's why.
No, in that case, you see, first you have to establish your right, title and interest over that plot of land.
My lord, that is the question that read
Without any document, merely on your verbal submission or on the basis of minutes of the meeting, can this court pass any order?
My lord, no, the court cannot pass an order for unfreezings of their account on the basis of their prayer. Inasmuch as 37 lakhs compensation was disputed amount. Because the disputed amount should not be.
No, where is the document?
My lord, that I have submitted that the judgment also passed by the judge in
No,
Telangana also.
that may not be applicable in the present case.
Well, this is exactly same. The law is that then they pray for the freezings of the account, freezing of the account. There is a disputed property, that amount of compensation, a money. Then the court allowed to use that at their account, except that disputed property, this disputed amount should be on hold.
Okay.
It is directly to
My
the
lord.
case.
Any reply?
My lord, I just want to reply that my learned friend had focused on the land composition. He did not focus how they illegally occupied my plot of land. He did not focus. If he wants to focus on the land composition, he has to focus how they possess, how they occupied the plot of land. Then I just want to rely this passed by the apex court. May I read out, my lord?
So can I have the citation, please?
Paragraph number?
Where I was marking by a that 12.2 citation is Vijay. The right to property ceased to be a fundamental right by the Constitution, 44th Amendment Act, 1978. However, it continued to be a human right in a welfare state and a constitutional right under Article 300A of the Constitution. Under 300A provides that no person shall be deprived of his property save by other authority of law. The state cannot dispossess a citizen of his property except in accordance with the procedure established by law. The obligation to pay compensation, though not expressly included in Article 300A, can be inferred in that article. 12.3, to forcibly dispossess a person of his private property without following due process of law would be violative of a human right, as also the constitutional right under Article 300A of the Constitution. Then Reliance case law was mentioned under this, and from this case law it is very clear that the tourism department had illegally occupied my land. And that occupation, that illegal occupation, violated the Article 300A of the Constitution as well as human right. Then in this respect, my learned friend has submitted that there is no money for acquisition in the project, in the central project scheme of tourism department, which was annexing the counter affidavit. Annexure 1 of the counter affidavit filed by the respondent number 5. It is
Okay.
not.
My lord, that
Then, let me finish, my lord. Then, that is my first point. Then the second point is, if the tourism department had no, the tourism, before that, I want to submit that the affidavit, counter affidavit filed by the respondent number 4.
No, you have already submitted on
Yes,
on the
I
counter
yes, I
affidavit.
already submitted. My
Don't
lord.
repeat the same thing.
No, my lord, I just want to say this one. Counter affidavit filed by the Kala stated that they purchased my landed property. And the counter affidavit filed by the tourism department also said that they purchased. But in the record note which they relied, has stated that they donated. Which one is correct? It is very doubtful. Because of that, the way they occupy my land is very, very, very doubtful, and it is completely illegal. Then another my submission is that whatever the structure mentioned by my lender friend, all the structure was taken in my name, and tourism department is not in the picture as in page number 24 of my petition. How can they say that we constructed and this belongs to me? Because they have no evidence to prove that all the structure which was assessed in the name of the petitioner belongs to them. Because of that, they have no right to claim. They have no right to claim land compensation upon my land. Then as per the case law which was cited by my lender friend is that the court can freeze the bank account, but it did not mention that Kala has right to freeze the private bank account. Because of that, court can freeze my account, but Kala cannot freeze my account. Because of that, I'm praying to this honorable court to unfreeze my account. And regarding the dispute in apportionment of the amount, then the civil court should settle the matter, but not the Kala. But not the Kala. Because of that, the Kala has no right to freeze my account. That is my main point. And the tourism claiming the land compensation upon my land is also, they have no right to claim.
Okay.
My lord, interim order.
Because
allow me to read
because they are
interim order 23.
Because they violate my
23.
they violate my constitutional right. Well, when they freeze my account.
Okay.
My lord, allow me just interim order that observation in
Interim order, I have gone through it.
My lord, that one point that I would like to reflect, very important point, that just above the para, it's order 22 March 2024. So that last two para, that having heard the last two. You're there? Having heard the learned counsels or the parties, upon perusals of the pleadings on record, prima facie, it is written prima facie, it appears that the amount of rupees 3717 such and such has been the amount decided by respondent number 4 and the other competent authority as adequate compensation is required to be paid to the petitioner for acquisition of land. And under such circumstances, this court is the prima facie of the considered view that till the next date, petitioner should be allowed to operate the saving account number such and such. Here, the word is that they should be allowed to operate only the saving account. However, to furnishing and taking that the bank that in event of any adverse order is passed in this proceeding, petitioner will be liberal to refund the amount as may be decided by the court. And the respondent number 4 will be entitled to recover the same by due process of law. This is what it is written, my lord. It is before tourism department was implemented as a party.
My lord, in this
So, my lord,
petition,
my
we are
point is
claiming to avail our right, my right. We are avail to claim my right only.
My lord, then after
Then-
this,
then-
they tried to withdraw this writ petition, saying that it became infructuous. We already received the 37 lakhs and we all withdrew the amount. They withdrew amount already. Even last occasion, they submitted that only 1,000 something was remaining in this account.
That 37 was determined.
That is subject to-
Determined.
And my lord, my humble prayer is that they return it, then it should be decided as per 3/8, as per the law. So they can use, then they can, the court can defreeze their account, they can use it. But that 37 should be on hold. Then under section 3/8.
My lord, how can they say that 37
Kala
should be?
will decide as per the law. Because there is no violation of.
Kala has no right to. Kala has no right to decide the amount.
3/8 is very clear. They are the
Which was
authority.
already awarded.
They have the power of civil court also. It is written in the law.
Let them file it in the civil court. If there is a disputed fact on their part, they can file it before the civil court.
Heard Ms. Jacinta Zathon Mam, learned counsel for the petitioner, and also heard Mr. J.C. Lalnan Sangha, learned counsel for the respondent number 5, Ms. Mary L. Kyangte, learned government advocate for the respondent number 4, and Ms. Who appeared for
Zainab
respondent number
Sampui.
1 and 2?
1 and 2 is
Laldin Puya.
Laldin Puya. That it is there in the cost list, Lordship.
Okay. Laldin Puya,
Zodin Puya.
Zodin Puya.
Jodin Puya, learned counsel for the respondent number 5, and Ms. Zairam Sangpui, learned CGC for the respondent number 3. Argument concluded. Order reserved.
Much obliged, Lordship.
Yes.